Lordship. A very good afternoon, Your Lordship. This is counsel representing the appellants Suhani and others invoking the jurisdiction of this court under Article 136 of Constitution of Saurashtra, which deals with special leave to appeal by the Supreme Court. Your Lordship, the brief facts of the case are: Raghav, a boy from state of Uttar Nivas, wanting to be an actor, started his career as a background dancer and got his first break in the web series Hell, where he came into...
But his voice is not clear. Please make his voice a little bit, louder. You check the voice.
I'm increasing it from my end.
Yes, please speak. We'll see.
Am I audible now, Your Lordship?
Yes, there is some difference. Okay.
Lordship.
Okay, start now.
Your Lordship, the brief facts of the case are: Raghav, a boy from state of Uttar Nivas, wanting to be an actor, started his career as a background dancer and got his first break in the web series Hell, where he came into contact with Rajiv Singh, one of the appellant in the case. He is a producer. Rajiv turned Raghav's life from a struggling actor to a well-established actor, and due to which he started getting movie offers, and also many other big fame directors wanted to work with Raghav. Meanwhile, Rajiv introduced Raghav to a girl named Suhani, who is appellant number 1 in the present case, who is also a famous model and a part-time actress. Your Lordship, Raghav and Suhani, by the over time, got closure as both of them signed up for an upcoming movie named My Girlfriend, which brought both of them together, and they were open about their relationship to the media, about dating each other. Years passed and Suhani introduced Raghav to 2 of her close friends. All of them had a very good relationship. They would go to big house parties together. Raghav and Suhani purchased a 4 BHK apartment and started living together. After them living together, the family of Raghav would always complain that Raghav is busy and does not make time for them. Your Lordship, on 23rd of February 2021, through a local newspaper, the family found out that their son has committed suicide. Considering the situation, on 28th Feb 2021, the Finance Directorate filed a money laundering case, and the Awadh police filed the FIR under section 341, 342, 380, 406, 420, and 306 of the IPC against all 4 of them. Your Lordship, during the investigation, the Finance Directorate came across a drug angle and requested the Drug Check Bureau to file a case. The same was filed under section 20, 22, 27, and 29 of the NDPS Act 1985.
Mr. Counsel, do you have an FIR with you?
No, Your Lordship, we are not provided with an FIR in the fact sheet.
Please carry on.
After that, Your Lordship, the 4 appellants were arrested and produced before the judicial magistrate, which sent them to a 6-day police custody. A bail application was filed in the Sessions Court stating there was no concrete evidence against them, and the Awadh police is acting under immense pressure by the media and also the public. Your Lordship, on 8th of March 2021, the Session Court dismissed the bail application and sent them to a 14-day judicial custody. On 10th of March 2021, they filed a bail appeal to the Honorable High Court of Awadh, contending that they were not given the opportunity to present their case, and the investigation agencies have been acting under immense pressure by the media and the public. And also that there exists no concrete evidence against them. It was pleaded before the Honorable High Court of Awadh to stop media cover-ups as they are flourishing stories. It was also prayed to transfer the case to the CIO inquiry. The State Council pressurized the court, contending that it is a sensitive matter and granting bail would worsen the situation. Under hustle and tussle, the Honorable High Court of Awadh ordered 6-day judicial custody and Drug Control Bureau and Financial Directorate to file a charge sheet within 3 days, and stated that the question of transfer of the case to the CIO does not arise. Your Lordship, aggrieved by the same, we have filed an appeal in Honorable Supreme Court and hence we are present here. Your Lordship, the Council seeks permission to proceed with the issues.
Please.
Much obliged, Your Lordship. Your Lordship, the Council will be dealing with the issue number 1 and issue number 2, and issue number 3 and 4 will be dealt with by my co-counsel. The first issue is whether the High Court had wrongfully tried the case and whether it was ultra-vires for them to charge appellant in the accordance with Saurashtra Penal Code. And second issue is whether the media be stopped from covering the matter. The third issue herein is whether the appellants be granted protection from any kind of arrest from Drug Control Bureau and Financial Directorate. Fourth issue is whether the following case must be transferred to CIO, which is a Central Investigation Agency, for investigation. Your Lordship, the Council seeks permission to proceed with the arguments.
Please.
Much obliged, Your Lordship. Your Lordship, it is humbly submitted before this Honorable Court that Supreme Court has evolved a legal principle that if by a plain reading of the FIR, no statutory offense can be made out, then the accused person cannot be held as liable. The foundation.
Can you cite a case?
Indeed,
It can't be theory.
indeed,
You
Your
said
Lordship.
Supreme Court has said so. It must have been laid down as a rule or a law somewhere in some judgment.
Indeed, Your Lordship, after stating every section under which appellants has been booked, I will state the case.
Mr. Counsel, you have not understood what I am saying. I am saying you are making a rule or you are citing a rule of the Supreme Court, right? Where the High Court cannot do this. Where is it? Is it a statute? Is it a rule? Or is it the case decided by Supreme Court?
Your Lordship, it is a legal. Your Lordship, the
where is it stated now?
Right now,
where is it stated?
The Council
in the
humbly,
judgment.
the Council humbly pleads ignorance. Right now, I don't have the case with me which states.
Please carry on.
Much obliged. Your Lordship, a plain reading of the allegations reveals that the appellant took money from Raghav and mentally tortured him. This is cited as the reason he committed suicide, although these allegations are unsubstantiated. It is not illegal to spend the income of your live-in partner. In fact, a lot of high courts have recognized the live-in relationship to have the same legal sanctity as marriage. Raghav transferring money to the appellant out of a place of love and affection cannot be treated as crime. Your Lordship, even if the allegations are taken in their entirety and solely at their face value, yet the Council most humbly submits that no offense is committed under Section 306 of IPC, as the Act does not fit into the definition of abetment as defined under Section 107 of the IPC. Moreover, the Council submits that the accused have not committed the offense under Section 420 of IPC and Section 406 of the IPC. Your Lordship, according to Section 107 of the IPC, a person abets the doing of a thing who first instigates any person to do that thing, secondly engages with one or more other person in any
Counsel, you said the deceased person, he came from a humble background.
Indeed,
and he worked hard and he earned a lot of money.
Indeed, Your Lordship.
And when he finds that somebody is taking away the whole of the money, and he feels that all what for he was striving is not with him and he is in a trap. So is that not indicative enough that the intention was to take him to death and to be safer that he should kill himself by himself? That's very much evident from the facts, no?
Your Lordship, the deceased, Your Lordship, the deceased has struggled a lot in this industry and made a name of by himself. And it is nowhere mentioned in the fact sheet that the transfer of money was a forceful act, or there is not an iota of evidence which supports this theory. It is nowhere.
Counsel, should the transfer always be forcible? Or it can be somewhere by a deceitful means also.
Your Lordship,
I can be a good friend of yours and take everything without forcing it.
indeed, Your Lordship. But in the present case, one of the appellant is his live-in partner, who is living with him from the past 2 years. They both purchased a 4 BHK flat. They were in love and they were living partners. One of the appellant is a producer who himself launched him, who himself made him that big star. So I don't understand the theory. How can the person who is earning equally to him or more than him want to take money from him?
How can this be argued, sir?
So
Mr. Counsel, how can this be argued? It's a human behavior.
Your Lordship,
I am a good friend of yours for the first 2 years when both of us are earning handsomely, right? After 2 years, my whole intention or my behavior changes. I want to kill you and grab whole money. How can you stop me and say this argument that no, both of us were friends, we were earning together, we were in a flat together?
Indeed, Your Lordship.
Then what's the argument?
Your Lordship, for a case of abetment of suicide, there must be evidence of instigation or
instigation is not the only method. Go on reading section 107, sir, please.
Your Lordship, under section 107, it states first either it instigates any person.
Okay.
Secondly, it engages with one or more other person in any conspiracy.
Second is aiding and abetting. Yes.
And thirdly, intentionally aids by any act or illegal omission the doing of that thing. Your Lordship,
Can it be omission? Can it be methods of omission? Whatever the methods the partner has used, can they not be the methods of omissions? That he pretended to be like this, he was not like this.
Indeed, Your Lordship, but for a case to fall within the abetment to commit suicide, it is not what the deceased felt by my action. It is what the accused intended by his act. And the accused here...
Sir, how is intention reflected? The intention is reflected in 2 ways. One, that I be active and participate in the crime. So my intentions become so apparent that there's no evidence needed almost.
Indeed.
Isn't it? The second is possibility that I may become in a very different way as a good friend of yours, right? Cheat you in a different way, take liquor with you, take signs at the time when you are completely seduced or drunk. So can't it be the intention in a different way? How is intention only by intention? There are many methods of intention.
Indeed, Your Lordship, the second point you mentioned, without intending that also, but for that there has to be some iota of evidence to support that theory. This is only a theory, and based on just theories and wild accusations, you cannot put appellants into the jail and cannot deny them bail.
Do you have the facts as to how much money was transferred directly by A to B?
Indeed, Your Lordship, it is nowhere mentioned in the fact sheet.
Then how do you say that the money was taken by the B?
In the fact sheet, it is only mentioned that the police, while investigating, had found some...
Sir, how can it be? Either you should have his account, which must have swollen from 500 rupees to 5 lakhs of rupees. Within that specific period of time, then we can say it's an evidence that within a period of 1 month, his account has gone from 500 to 5 lakhs. Suspicious, not knowing the source where from it has come. Or we know the source where it was from.
Yes,
so Your Lordship. Is any of the fact before you?
Yes, Your Lordship. In the present case, the onus of proving that these transactions are illegal or suspicious, it is on the prosecution.
Not at all, sir, please. Not at all.
Sir,
don't go to the dogmatic criminal law. It's not on this.
Your Lordship, in the
direct case where the person who alleges something has to prove it. You are alleging something, you have to prove it.
Indeed, Your Lordship.
It must be immediately transferred.
Your Lordship, in the present case, the police has found some bank receipts. They have found the source of transaction.
Now you are on the line. Yes.
They have found a source of transaction, like some money was transferred from one account to another account.
Right.
If they wouldn't have found the source from where the money is coming, that can be suspicious. If some money transfer is happening and you have provided with the proof that here's the bank slip, then how can this transaction be suspicious? That can be, they were in the Bollywood industry, they were in the film industry, where it's where the income of the individuals are little more than the other people in the country.
Let's come to law, please. Carry on.
Read your Lordship. Your Lordship, according to Section 4, it is humbly submitted before this Honorable Court that offences other than Section 306 for which crime is registered against the appellants herein are Section 420, which deals with offence of cheating and dishonestly inducing delivery of property, and Section 406, which deals with punishment in respect of criminal breach of trust committed. Your Lordship, according to Section 405, the offence of criminal breach of trust is committed when a person who is entrusted in any manner with the property or with any dominion over it dishonestly misappropriates it or converts it to his own use. Thus, in the commission of the offence of criminal breach of trust, two distinct parts are involved. First consists of creation of an obligation in relation to the property over which control is acquired. The second is misappropriation or dealing with the property dishonestly, contrary to the terms of the obligations created. Your Lordship, in the present case, both the conditions are missing. The police, the facts nowhere shows that there was an obligation on the behalf of appellants for some property and they failed to fulfill it. So far as Section 420 is concerned, there are essential three ingredients of Section 420 that are cheating, dishonest inducement to deliver property, or to make, alter, or destroy any valuable security. And third one is mens rea of the accused at the time of making the inducement. It is most humbly submitted before this Honorable Court that appellant neither poses the mens rea nor made any action to commit the offence under Section 420. There is not an iota of evidence which has been produced by the police.
Counsel, can you explain what could be the possible motive for transferring the money from somebody's account to others' account? What could be that now? See, if somebody is living as friends, that can't be a huge amount for necessities, for other things, for a trip. But when a very huge amount is transferred, it is itself showing the intention that there was a guilty mind. And though they played it in a way to show it, it's not like that. So the amount itself shows when it is in lakhs and lakhs and lakhs. So it shows there was a guilty mind. What could be the purpose for which it was transferred?
Indeed, Your Lordship. Your Lordship, the appellants and deceased were not only close friends, but they were also in a professional relationship.
Mr. Counsel, in the first place, you said that for criminal breach of trust, there should be some trust. And at the same breath, you said because they were separate partners, there was no question of trust as first part of your 306. Now you are repeating that they were very close friends. What is closeness? Is it trust or simply English closeness?
Indeed, Your Lordship. Your Lordship, trust was there as a close friend, but there is nowhere mention that.
The mention is not necessarily with her.
That accused.
Not necessarily that it should be mentioned.
Indeed, Your Lordship.
I am married to my wife. Where do I write that I trust her?
Indeed, Your Lordship, I'm not talking about the trust here. I'm talking about the property or any valuable thing which has been trusted with his close friends. Yes, indeed, there was trust between them, but where is the property or where is the valuable security that the deceased trusted with them?
Okay.
Can I continue, Your Lordship?
Yes, please.
Okay.
Your Lordship, the producer who helped him in this journey of becoming a popular actor is accused of taking money from him. Transferring of money between accounts of friends or colleagues is not a suspicious thing. The family of the deceased were living in a different state and had no idea about the everyday life of the deceased. It was his friends who were close to him. Blaming the appellants for every act of deceased, be it smoking or drinking, is ridiculous. The family of the deceased are trying to make his friends scapegoat in the present matter with their wild theories.
No, see, counsel, even if they were elsewhere, naturally, if somebody was getting very high, they would have had expectations.
Indeed, Your
And that's how they would have had expectations from him of taking some care at least, and also sharing some of the bounties which he had in life. But they are the best persons to know that there was somebody in between. And those in between people, they were taking away the money, they were sharing his reputation, they were, not letting it possible for him to give a look towards his family, towards relatives. This is very much obvious. And they are the best people who can say it. Oh, that's
I beg to differ, Your Lordship. The accusations of the family that Suhani used to control and dictate the deceased is the result of deep-rooted patriarchy in our society, which vilifies the woman even for the deeds of men. The deceased was a grown-up man who has made his career in a highly competitive industry on his own. He was not a child. Then how can Suhani and his friends control his life?
Good.
Your Lordship,
that's
Very good emotional argument. Very good emotional.
So that's we appreciate the talent of the council.
Council, yes, yes.
But at the same time, we can see that how human being is strong and how human being is weak. So both aspects will have to be taken note of. Okay, you proceed ahead, please. Please proceed ahead with your argument.
Indeed, Your Lordship. Your Lordship, I want to add a report of National Police Commission in its third report referring to the quality of arrest by the police in Saurashtra mentioned power of arrest as one of the chief sources of corruption in the police. The report suggested that by and large, nearly 60% of the arrests were either unnecessary or unjustified.
But Mr. Council, the report is of 1983. The report is useless. We have amended arrest. 41 has been amended in CRPC in 2008/2009. And 41 B, C, D have been amended in October, whereas the other sections were amended early in January. The arresting powers have been given wider sense. So you are saying a report of 83 is dogmatic.
Indeed, Your Lordship, but the situation haven't improved yet.
That's not the law, my dear counsel. That's not the law. The law is what is on the statute books. The law is not that what has been said in a report. And that too, the report which is almost 2 decades before. Sir.
Indeed, Your Lordship, but that report stands true till today. We have seen
in the I don't doubt about it, even if the Supreme Court puts it 10 times, but if it is not implemented, it's not there. The law in section 41 deals with certain processes of arrest, right? And arrest, even in 40 B, C, D, is an exclusive additional power given to the police. So if you have any argument with respect to that, the arrest was wrong, we are ready to listen to that.
Your Lordship, arrest was unnecessary since they were not given notice first of any
Mr. Counsel, is there notice for arrest? How an arrest is made? Who can arrest? Arrest can be made at any point of time.
Indeed, Your
Lordship. Arrest is not something which is so guilt.
An arrest can be made at any point of time when the police feels they have enough evidence. They have the enough.
No, police. When the police feels suspicious, they can arrest any person.
Indeed,
if you are walking to your office to Supreme Court or to High Court, then in between the police feels just sees the person suspicious, they can take you to custody.
Indeed, Your Lordship.
That's there. There's nothing like that.
Indeed, Your Lordship, after taking to the custody, they have 24 hours. They have to produce me before magistrate, and they have to prove why they have arrested me. What is the suspicion? And in the present case, there is not any evidence or logical reason. The arrest is totally unnecessary as one done in haste under public pressure and without any concrete evidence.
Why do you say arrest is unnecessary? How do you say, Mr. Counsel? If some act has taken place and there are allegations against me or you, then naturally the police will arrest us because we are the first suspects.
Indeed, Your Lordship.
And then how do you say arrest is wrong?
Your Lordship, in the present matter, the arrest was done after on the allegations of the family, and only crime appellants here did was they were close to the deceased. Just because they were close to deceased, that can't be the reason of arresting them. Because they were close to this, they knew they must be the reason of his suicide.
Is the word only close written or something else? Go to your fact sheet.
Indeed, Your Lordship.
Only close word is written that they were close. That's why he was arrested.
Other than, indeed, Your Lordship, other than that, it's written they used to go to house parties together. But other than that, all the evidence they have produced, that is not at all suspicious. Just like I proved before you, how can a bank receipt be suspicious if transferring?
Okay, counsel, tell me, see, do you want to say that police was corrupt and so they arrested them?
With due respect, Your Lordship, I want to say that arrest was unnecessary.
You were referring to some report. So what should we infer from that? Tell us in clear terms.
The council just want to provide a data that in many cases they are unnecessary arrest, and this is one of
that's, see, if you want to tell us that thing, then money was this time in the hands of the accused. Money was not with the deceased person, no? So he could not have in a way influenced it through corruption. So you are giving an argument which does not fit in the circumstances, no?
Your Lordship, this is not an instant of it is not an instance of corruption. It is done under huge public pressure. Since the media trial is going on, it is done because of the media.
Mr. Counsel, I am really amused to listen. I am really amused because I am teaching rather than listening to certain things. Why do we arrest a person? Tell me. Even if it is pressure or no pressure, why do we arrest a person? What is the purpose of arrest? Is it punishment? That's why you are saying so?
Your Lordship,
you are looking at, please, you are looking at from the glass of punishment. Whereas arrest is not. Arrest, my dear friend, is preventive. Indeed. So we can take anybody who we say he has been arrested to prevent onslaught on him also. उसको बचाने के लिए भी arrest हो सकता. How do you allege that the police was like this and therefore this is doing like? Arrest कोई punishment नहीं है.
Indeed, Your Lordship, police have arrested them for investigative purposes. I agree. But the same investigation can be done without arrest also.
How can it be done, sir?
Because they are not...
I need an accused person.
Your Lordship, they are not perpetual offenders.
That's not the argument, sir. Even if I am an occasional offender, if the police feels that my presence is necessary, they will do it. Except that they will have to get the permission from the court of law after 24 hours, which is known as remand, right? That they will keep the accused with them and will go on investigating. There's nothing as released.
Indeed, Your Lordship. But Your Lordship, for police to take them into custody, there has to be some suspicion. They have to prove
suspicious
court that why
respected counsel.
Indeed,
it's not dal mein kuch kala hai. Yahan to sari dal kali hai.
Your Lordship, there has to be prima facie a case. As I mentioned.
What do you mean by prima facie, sir? Apparently, it should look like that, right?
Your Lordship,
me and you are very good friends. We are living together for some years. We have transactions, money transactions. We go to parties. Someday I was found dead in a room. Where will the suspect go?
Indeed, Your Lordship, suspicion can go to anyone, but there has to be.
It will go to Prime Minister of India.
Who is close to him, Your Lordship?
That is therefore who is close to him is to be suspected and taken for a custody. He's the first custodian. In case of death by the husband of his wife, the husband is the close one. So he'll be taken into custody for investigation. You are correct. He should have been taken for investigation. Investigation should have been done. If there is any fault in investigation, please speak on that. But arrest as such, I don't think can be wrong, can be right. I don't.
Indeed, Your Lordship. But in the present appeal, we are not talking about the arrest. We are here for bail, and for bail to deny a bail, the police has to prove that there is a prima facie case against the suspect. They have enough evidence to initiate an investigation. They can't put accused or appellants into the custody based on allegations.
Counsel, prima facie here is somebody was very close, somebody got the money in a very friendly manner, and it's full of, in a way, a kind of being a friend, enemy and friend. And then ultimately, when a person is disappointed by finding that his everything was lost, his money was lost, his love was lost, his trust was lost. So naturally, the outcome is that he will commit suicide, and police would arrest those who have done all that. Very clear, prima facie,
Indeed, Your Lordship. Your Lordship, the human mind could be affected and could react in a myriad ways, and impact of one's action on the mind of another carries several imponderables. We can't assume that this was the reason deceased did suicide. We can't assume just based on the...
Give him 1 minute to clarify. Okay. Okay, please. You clarify. Okay, give your...
Indeed, Your Lordship. Your Lordship,
yes,
we can't assume this is the reason the deceased did suicide, because the real truth was gone with him. And this is a family who's living all together in different state. How can they know what was going in the mind of the deceased?
Very good. Very good argument. This is a wonderful argument that all cases should be taken where we should have an authenticated things that somebody has committed crime because of some's intervention. How do we then discover suicides?
Your Lordship, indeed, Your Lordship. Your Lordship, even case to just the way I just mentioned 306 and 107, there is a specific principle. There is the specific ingredients which is given in the IPC.
What is that?
Your Lordship, I just mentioned those that a person abets at doing a thief who instigates, since all of the ingredients...
You are talking of one process of 107. Dear Counsel, you are speaking of 107A. There are three methods. One is investigation, another is aiding and abetting. The third is something different, isn't it?
Indeed, Your Lordship. Your Lordship, this is not all three. For all three,
they are absent.
They are absent and not a single ingredient in present in the present matter. Your Lordship, if I can have an extra 2 minutes, I would like to come to the issue number.
No, not at
all. The counsel humbly seeks permission to call upon my co-counsel to take up the further issues.
Yes, please.
Your Lordship, the counsel seeks permission to proceed with issue number 3 and 4.
Okay.
Much obliged, Your Lordship. Your Lordship, issue number 3 would be broadly dealing with whether the failure on the part of Drug Check Bureau as well as the Finance Directorate to collect the evidence would be a ground to grant protection to the appellants under the Narcotic Drugs and Psychotropic Substances Act 1985 and the Prevention of Money Laundering Act 2002. Your Lordship, the counsel would cover the first sub-issue, which is whether, according to the emerging drug angle and the investigation conducted by the Drug Check Bureau, the appellants must be granted protection from arrest under the NDPS Act 1985. Your Lordship, the counsel most humbly submits before the Honorable Court that the investigation that has been started by the Drug Check Bureau and that the case that has to be registered against the 4 appellants under section 20, 22, 27 and 29 of the NDPS Act 1985 is completely baseless. It's based on mere allegations by the family member and the emergence of drug angle. Your Lordship, in the fact sheet, there are only 2-3 aspects mentioned about the drug angle as such. That firstly, there is an emergence of drug angle in that particular city. And secondly, the discovery of local drug dealer Smith. Your Lordship, on the basis of these 2 circumstances, a case has been initiated against the appellants under the following sections of the NDPS Act. Your Lordship, the council seeks to place reliance on section 35 of the NDPS Act 1985, basically states that the NDPS Act, which deals with serious crimes of the society, there exists a reverse burden of proof in that particular act. That means the primary burden of proof would be on the accused to be discharged, and then the court will proceed further. However, Your Lordship, in these cases as well, Supreme Court has clearly stated, Your Lordship, the reliance was placed on a 2018 Supreme Court judgment of Mohanlal versus State of Punjab, in which the Supreme Court has clearly held that a fair trial to accused is a constitutional guarantee under Article 21.
Oh, Mr. Counsel, please.
Yes,
Is arrest against fair trial? Both of you are pleading something which is completely astonishing.
Your Lordship,
arresting a person is not against the fundamentals of fair trial.
Your Lordship, the arrest
arrest is a process of prevention.
Yes.
Trial is something different. The trial doesn't start from the word arrest. The trial starts only when 173 of the CRPC comes into action. That means when the challan or the police sheet is filed before a court of law. Then your bail and your plea and your NDPC, whatever comes into action. You are asking before arrest. Mixing arrest with something which is different.
Yes, Your Lordship, completely agree. What the councils are basically arguing, we agree that the case is in pre-trial stage. As far as the NDPS Act is concerned, the charges have yet not been filed. The council basically here wants to show that how the investigation or the case has been registered is completely baseless, as there's no evidence, any evidence against the appellants.
No.
And Your Lordship, arrest may be made in order.
Is it necessary that the charges should be filed and then only arrest can take place?
No, Your Lordship, I do agree with you on this particular point, but Your Lordship, the council simply states over here that the suspicion also does not arise with respect to the drug case, as there are no evidence given.
You said yourself that there are 3 main things on the basis of which one can be said to be suspect of drugs. One is prevalence of drugs in that city.
Yes.
I think your fact sheet, I do not know, has concealed certain things, but the actual case which deals with is full with drugs, isn't it? It's even proved now. There is a process where the drugs are being sold, and perhaps, I don't say with conformity, but perhaps this person too must have fallen into the trap of drug problem. We're presuming it. So on the basis of these presumptions, the arrest is possible. This is a presumption. Arrest is only on presumption. Arrest is not on finality.
Your Lordship.
Finality, there is an order either of bail or of no bail. But before that, one can be arrested and investigated. So you are putting one act as a hurdle to another act. You say, if this has not happened under this act, therefore it can't happen under any act.
Your Lordship, the appellants have been arrested. That has been very much agreed by the councils of the appellants as well. Further, we are basically arguing with respect to the bail that the denial of bail was not correct by the High Court, because they are not justiciable grounds to deny.
Why? Tell me why.
Yes, Your Lordship. As far as the previous issue is concerned, I will just elaborate on that as well. However, in my issue, in the NDPS and PMLA Act, no arrest has been made as of now.
Bail as a matter of right, particularly NDPS?
Bail as
matter of right? You are arguing like that.
No,
Is
Your Lordship,
bail as a matter of right of an accused?
Under the NDPS Act?
Rather any act, even under any ordinary criminal law. Is it my right?
Yes, sir. According to the fundamental right to have personal liberty, bail is a matter of right. However, it's subject to reasonable restrictions.
Madam Counsel, please, don't allow me to cry now. It's too much.
However, Your Lordship, it's subject to reasonable restrictions by
right to bail is not a matter of right. It is the discretion of the court, even if the offense is bailable. Read 36, 37, 38.
Yes, Your
Chaliye, please. Carry on.
Your Lordship, basically what we are arguing under this point is that the arrest should not be in the future date because the case initiated is on basis of baseless allegations, as well as the arrest that has already been made, and further the bail has been denied by the High Court, and that is not on a correct grounds. Because
that's what I'm saying. What are the correct grounds as per your state? High Court has denied bail.
Yes,
as per your statement that the High Court is wrong.
Yes, Your Lordship.
1, 2, 3 points. Tell me 3 points. Where is the High Court wrong?
Firstly, Your Lordship, the order delivered by the judgment of the order delivered by the High Court is not a reasoned order. The order that is
reason they are unreasonable.
There are no reasons specified as to why the bail was denied to the appellant from that which we can derive fact sheet.
That where the bail is denied, you have to specifically write as to why the bail has been denied.
No, Your Lordship, it's not a.
Where is bail? Where is bail in section 3 of the CRPC? Which section speaks of bail?
Your Lordship,
which provision of the CRPC speaks for bail?
Your Lordship, 437 to 439. Okay. Yes.
437. Read it perfectly. It says that the court may grant bail. So it doesn't say that in case of denial, the court has to give reasons. Has it to give reasons?
No, Your Lordship.
Then is the discretion what I'm saying? So you can't challenge the discretion by saying that the court has worked arbitrarily unless you prove like that.
Yes, Your Lordship, with the arguments that we are advancing right now, we'll be able to prove that the arrest.
Please. My pleasure. My pleasure. Prove it.
Yes, Your Lordship. Your Lordship, under the NDPS Act, continuing the arguments that I was advancing, the reverse in the acts, in the nature of acts which have reverse burden of proof also, the onus will lie on the prosecution to demonstrate on the face of it that the investigation was fair and judicious with no circumstances that may raise doubt about its veracity. Your Lordship, in this particular case, the prosecution has not discharged the primary burden of proof in the NDPS Act as well. There has been no possession of contraband substances proved. There's been no chats as such discovered as per the fact sheets which we can see that directly attribute the drug angle to the appellants. Even the local drug dealer Smith, who was recovered by the investigation agency, did not point towards the guilt of the appellants or was not even remotely related to the appellants in this particular drug case. Your Lordship, in this case, the council also seeks to place reliance on a 2015 Supreme Court judgment, which categorically deals with the aspect of burden of proof in the NDPS Act and states that if the circumstances prosecution evidence are such as to give reasonable assurance to the court that the appellant could not have had the knowledge or the required intention to commit the said offense, the burden cast on him under section 35 of the Act would be discharged. Your Lordship, the council's plea in this particular sub-issue is only that the case that have been initiated against the appellants is baseless. We do not have any evidence as such. It's only operating on mere suspicion, and this is a demonstration on the way how the agencies are functioning in a biased format. There are no messages, there are no letters, there are no evidences, and there's nothing in the fact sheets as such that attribute the appellants to the drug angle. Your Lordship, now the counsel for the appellant would want to move to the sub-issue 2, which deals with Prevention of Money Laundering Act. Your Lordship, in this case, in this issue, the council humbly submits that the evidences available on record, that is the fact sheet, clearly states that the investigation agencies have recovered certain bank receipts. That's it, that the fact sheet states that the recovery of bank receipts, certain evidences, laptop of the deceased that has been seized by the agency, and that has been the sole grounds for initiation of case under section 3 of the Prevention of Money Laundering Act as well. Your Lordship, the allegation that large sum of money was transferred is only family allegations, not yet been deciphered as to who transferred money to whom. The aspect of transfer has been mentioned and the recovery of bank receipt has been mentioned as per the fact sheet. Your Lordship, in this case, the council submits that the bank receipts, letter, evidences are not a conclusive proof for the initiation of investigation or a case against the appellants. Your Lordship, under section 24
Should there be a conclusive proof to proceed against the NDPS?
Your Lordship, this is Prevention of Money Laundering Act.
Oh, sorry. Under the money laundering, there should be a conclusive proof.
Yes, Your Lordship, I am coming to the aspects
So
of it.
any proof which is rebuttable cannot be applied to money laundering.
Your Lordship, just 1 minute, I'm directly coming to that point.
I'm being arrested on the charges that police suspects that I have 4 crores rupees, which are unaccounted. Police catches a diary which speaks of some suspicion about such money. Right? As per your argument, Mr. Counsel, then I should have not been arrested.
Yeah, Your Lordship, the money amount is also not stated in the arguments. There's only
amount. It only speaks of money. How much?
No amount.
You are talking of receipts found, laptop found.
Yes, Your Lordship. Can you please repeat, Your Lordship?
It does not contain the amount transfer.
No, Your Lordship. No.
Then what is in the laptop?
That has not been mentioned in the fact sheet, and we can't presume what was there in the laptop. But however, the mention is only of bank receipts and the transfer.
So bank receipts are there.
Just this term is there, that bank receipts have been recovered by the investigation agency, and the family alleges that the youth sum of amount was found. Yes, anyway. Yes, Your Lord. Your Lordship, with this, the council was moving forward towards section 3 of the Prevention of Money Laundering Act, which needs to have broadly 2 ingredients for any person to fall under that. Firstly, that they should be dealing with proceeds of crime as defined under section 2U of the Prevention of Money Laundering Act. And secondly, while they are dealing with proceeds of crime, the accused person should project the same to be an untainted property, Your Lordship. Both the things are absent in this particular case. Your Lordship, the council also seeks to place reliance on section 24 of the Act, which clearly states that reverse burden of proof is there in PMLA Act as well. However, the burden on the accused person will only shift if the primary burden by the prosecution or the respondent is discharged by some conclusive proof, some amount, even some suspicion, but that's completely absent in this particular case. There are no proceeds of amount. As stated by my co-counsel, that there are certain bank receipts. The transfer is also not mentioned, which is yet to be deciphered.
Bank receipts. Blank.
Yes, just the word is mentioned.
No, blank bank receipts.
No, Your Lordship, just the word.
Written. Punjab National Bank, nothing written.
No. No, Your Lordship. That's not mentioned, Your Lordship.
Bank receipt then. Receipt means received something, isn't it?
Yes, Your Lordship.
Received, it means some money exists there.
Yes, Your Lordship, I completely agree. However, the amount, how much, the extent, the quantity has not been specified as of now.
For money laundering, is the quantity specified in the Act?
No, Your Lordship. However, they need to show that they are proceeds of crime. And then if I am accused, if I'm the accused person, I need to project it to be untainted property. That's
council, they have mentioned lakhs, not thousands and hundreds. No. So there is some mention when in our country we refer to big amounts, we talk in terms of lakhs. No, that means it was a very substantial amount. And then another thing is that High Court permitted remand. And if we grant bail, then how shall the authorities proceed with the investigation? Only, the possible in the situation is that they should be, available anytime for a genuine investigation of the things. What could be the possible mode, other possible mode of investigation into the matter? If this is not the genuine one, what could be the other possible? So in the given situation, when you say there is only the doubt, but the doubt is very strong, and anything begins with that. It's not merely the question of whether it is money laundering, whether it is NDPS. You can't quantify it that way, but we find the situation is such that it needs an immediate action, appropriate action, and availability of the accused. And then if there is any alternative way, you can speak that, present that before the court.
Your Lordship, I completely agree with your point that cooperation in investigation is the utmost important, and that's what we are looking forward. Your Lordship, as already stated, I would like to again reiterate the factor that the appellants in this case are not perpetual offenders. The mere fact that they were close to the deceased at the point of time when he died cannot be the sole grounds their rights are restricted, and they are not granted the liberty that
Counsel, it's not a case of pickpocketing, no, that we will count the incidents, how many times they have done it. It's basically a kind of a situation where we can say, yes, they might have been. We don't know it. And the case is of the nature that for years together, they might have been committing a guilt which they were not allowing to feel. It was a very sophisticated kind of action that was going on for years together. So it does not mean habitual here, cannot mean that it should be, we will count the incidents and then say, yes, it was habitual. It is, this is a chain. And that chain is so good that even if it looks as a one incident, but it is having many multiple incidents as the money was being transferred once in somebody's account, another account, and like that, this shows it. There was a tendency. There was something had happened which had developed into a habit also. And then the deceased, he was not also able to, as the fact sheet says, he was not also able then to, resist the temptation on the other side. So that's how, this is a very strong kind of feeling. I will not say a doubt, a strong kind of feeling, a genuine feeling that the availability of these people must be anytime, and at least for 14 days. I think this is quite genuine.
Your Lordship, yes, Your Lordship. Your Lordship, in this particular scenario, the counsel would want to respond that if we go according to the facts of the given case, if we go according to the facts given in our fact sheet, merely the fact that they were living together does not be the sole ground for the rise of suspicion. What the counsel argues is there are no other factors apart from the allegations of the family members, apart from the whole scenario, apart from the circumstances of the case. There are no links on the basis of how so much of a suspicion arises that they are remanded to a 14-day custody by the session court and again by a 6-day custody by the high court. The level of suspicion, Your Lordship, in this particular case is clearly high and is clearly biased by the media and other factors operating. We completely agree that we would be ready to cooperate. It's our client. Yes.
So you cooperate, be available. Why are you seeking the bail? No, be cooperate, because this is such a case that you are needed now continuously. There should not be a break in the investigation in such a very sensitive case. So you cooperate.
Your Lordship, in this particular scenario, the counsel would want to respond that we are there in that particular city and we are ready to cooperate with whatever investigation is happening. However, continuing the custody of our clients would be completely against the principles of natural justice, Your Lordship, because according to the fact sheet, if we go by the fact sheet, the only thing that we are relying over here is that the appellants were close to him.
No, natural justice will apply if there is torture, if there is coercion, if you are not allowed to say something you want to say, then natural. But we all only want you to be available. This is a very sensitive case. You should be with us for some days. It's not a, time limit is also given under the statutes. We can have this much. So cooperate and be there.
Your Lordship, in this particular case, counsel would want to respond that these are persons who are living in a city and affording their own income. Your Lordship, in this particular case, even 1 week, 2 weeks of custody drastically not only hamper their financial health, but Your Lordship, their mental health as well.
The cost of justice.
Yes, Your Lordship.
And the cost of the national justice or the national security Their income is important. Such cases can happen tomorrow in the industry again. How to stop them? To think that they are earning, therefore we should not. We should allow them to happen as to what is happening.
Your Lordship, the council completely agrees on this point. However, the mere fact depriving few people on mere suspicion would go against the principles.
I've been repeating it. Suspicion is a ground of arrest. Why are you saying so? You have not read it well.
Can you
Police
please
can arrest any person
Yes, Your Lordship.
on the basis of suspicion.
Yes, Your Lordship.
Call that arrest, you call that violation of your fundamental rights. I don't know how long you have taken it. That's what has happened actually in the actual case.
Your Lordship, the basic...
You unnecessarily drag the arrest in such a way as if heavens have fallen. The arrest can be done by any person, irrespective of his status. Right?
Yeah,
If
yes.
he feels suspect, he can be arrested, which is a preventive process, or just for the sake of inquiry. And if prima facie they find that they cannot complete the inquiry within a specified period of time, they will seek the permission of the court to grant extension, which I said is known as remand, and can carry on. When they are on remand for 10 days, for 15 days maximum, right? That's not a violation. Even if they are found not guilty after that, that's not a violation. There's a procedure.
That's
how
not
to reach to the case. That's not the procedure?
Yes, Your Lordship.
Is that not the procedure?
Yes, Your Lordship. However, in this particular case, in this particular issue, what we are arguing is that with respect to the Prevention of Money Laundering Act and with respect to the drug angle, which has not been yet proved by the or yet established by the even by the prima facie suspicion if we go. So with respect to this, they should be granted protection, Your Lordship. As far as the other Indian
Counsel, even if we grant bail under this provision, still
Yes,
the
sir.
basic thing, they cannot be granted bail. So they are still under the arrest.
Yes, Your Lordship. However, what the counsel for the appellants are trying to convince this particular court is that the continuous arrest or the continuing keeping the appellants in the custody.
The continuous arrest is then any word
Sorry.
like continuous arrest.
No, the continuing keeping the appellants in the custody is not
That
correct.
must be under law. That must not be under without any reason. You can keep a person into custody as per law. If you do not do so, you will be taken to task. The police can keep a person for 15 days in remand. After that, they have to put it in the judicial custody.
Yes, Your Lordship.
And then there's nothing else continuous. As long as I cannot reach to the drugs of the case, that's the bottom of the case. I may need the presence, as my brethren has said, we may need the presence of the accused for the perfect investigation. It's not question how long. You must have seen cases in Delhi where the High Court has released them after for 6 years on the basis of suspicion of terrorism. Person was arrested at one place, was suspected to be a terrorist, and that continued. After 6 years, he was found, no, he's not the person or he's not guilty at all, was released. That person can't do anything. We have not developed that sort of victimology yet, that he is a victim of unjust and other reasons. That's the law. If it happens with me, it can happen with me. It can happen with anybody. Except that if the police is violating the law, we will take the police to task. Tell us, has the police violated the law? They have done something of their own?
Yes, Your Lordship. To this, the council would also point that how the drug angle emerged, that the finance directorate itself, without any allegations, came across a drug angle, and suddenly the case was initiated against the appellants. Your Lordship, let's consider example that there is a drug racket operating in my vicinity, in my area. How are they attributing it to me? How are they charging it to me? Even if the suspicion arises in this particular case, Your Lordship, there are no grounds that the protection should be denied to the appellants in this particular scenario, in the drug case and in the prevention of money laundering case, Your Lordship. And as far as the other sections of the IPC is concerned, our clients are completely ready to cooperate with the investigation. They were there at the time of the incidents. They were there here, and they are ready to cooperate with the investigation, whatever happens. They're just seeking their liberty, and they're just seeking the relief so that they can move ahead in their life. It's a big shock and trauma for them as well to lose someone close to them, and keeping them and continuously charging them and continuously questioning them and keeping them away from their own social life would impact their mental health as well. So understanding the scenario, understanding
all emotional arguments. Tell me one thing, Madam Counsel. Is there power to the directorate to go for searches and seizures on when they feel suspicious about drugs in any locality?
Yes,
For
Your Lordship.
example, is it?
Yes, Your Lordship.
Then why are you saying where from the powers arise? If the directorate has a power so moto to go to some locality and to find out whether drugs exist there or there are drug addicts and other things, they can go and find anybody, including me. So finding in me also as part of the drug addict or a suspect is not the violation, provided we have the powers. I do not know. Please check it. Whether they have the power so moto to go, isn't it? I think
Yes, Your Lordship, they do have.
Arrested, accused. Then
Your Lordship,
it is the law at all.
Your Lordship, in this particular case, the issue is that on the basis of the facts, we cannot decipher as to how they would conduct search or seizures, because there's no discovery, there's no recovery, there's no search or seizure. There's nothing mentioned as such in the fact sheet regarding the drug angle, except the fact that the city had a drug angle in a holistic manner, and straight away the case has been registered. The local drugsmith dealer has not also attributed the appellants. So if we see the fact sheet in a holistic manner, Your Lordship, there are no conclusive proof or evidences, even for the search or seizure, Your Lordship. That's what the council humbly submits before the court.
Let us see.
Your Lordship, the council would quickly move on to the last issue, that's issue number 4, because of the paucity of time. Your Lordship, the issue number 4 basically deals with whether the case should be transferred to a central investigation agency or not. Your Lordship, the council most humbly submits that the case should be transferred to a central investigation agency, as we clearly see. Your Lordship, 1 minute extension. I would just quickly sum up this particular issue.
2 minutes, go back.
Okay. Your Lordship, in this particular case, council humbly submits that we can clearly see the various authorities operating. First is the Finance Directorate, first is the regular court, and then we have the Drug Check Bureau also coming up. So we clearly see that merely the fact that Finance Directorate came across the drug angle and the case was registered without any factors or without any evidences.
We're arguing exactly on the point of transfer of case.
Yes, Your Lordship.
Should it be transferred or should it not be transferred?
Yes, it should be transferred, because we can clearly see certain biased nature operating in the case. We can clearly see that with the state agencies, Your Lordship, we can clearly see a certain bias emerging in the case, Your Lordship. The media houses and the public pressure is clearly playing a dominant role, and in this case, an impartial investigation by the central agency becomes inevitable, Your Lordship. And the council for the appellants places reliance for this in Subrata Chatterjee places reliance on a 2014 Supreme Court judgment of Subrata Chatterjee versus Union of India, in which courts have clearly stated that to discover the truth and to meet the ends of justice, or because of the complexity of issues, the court can clearly transfer the case to a central investigation agency for a more impartial probe. Your Lordship, according to the arguments placed before this honorable court, we can clearly see a slight impartial or bias in the investigation, in the trial process, in the registration of case by the state police. So the appellants humbly submits that the case should be transferred.
I don't know. Please, I have not read the full facts, basically, to be honest about your fact sheets. But what originally the case is, I think this argument of yours is completely contradictory to the rest of the arguments.
Your Lordship, our fact sheet is drastically different from what the original case is. We completely agree on the same. Your Lordship, the appellant side is...
Please, Madam Counsel, on the one side, you are pleading for all leniencies, bail and other things, and their right and other things. On the other side, you are saying that it should be transferred to the central agency.
Yes, Your Lordship.
See, that was an argument from the other side.
Your Lordship, in this particular case, why we are arguing that the case should be transferred is because the biased investigation is conducted against the appellants. Even if we want to, the case should be transferred to the Central Investigation Agency. According,
you give her 2 more minutes to clarify.
Okay. Your Lordship, on the basis of facts of our case, not to what happened in reality, according to what we have understood as per the facts and circumstances of the case, the investigation is clearly biased, Your Lordship, and the counsel would also want to quote a 23rd.
How do you say it's biased? No, arrest is not proof of bias. No, they have to take. The police has not to strike its head with the wall and sit idle. How can they investigate? They have to arrest. No?
Your Lordship,
how can they do their job otherwise?
Your Lordship, in this particular case, the counsel would want to say that the mere family allegation that the huge sum of money was transferred from deceased to the appellant's accounts have been taken.
Now it is a fact. It's a fact. Even family is talking on the basis of certain facts.
No, Your Lordship, the counsel to this would like to reply that the only fact is bank receipts. Large amount of transfers have not been yet stated by the investigation agency. That's mere allegations. So incorporating the allegations into what kind of offense we would frame against them, it's clearly a bias on the part of the investigation agencies. Allegations cannot form the part of incorporating and then drafting what kind of offense would be generated.
Yeah. So you must be happy with the investigation, and you must be happy with the facts being verified from different documents. And the police should be allowed to do it.
No, Your Lordship, in this particular case, what counsel is arguing why the case should be transferred is that, firstly, the investigation is clearly biased. It's incorporating allegations and then drafting what kind of offenses can be made. Straight away, no evidences in the fact sheet, nothing mentioned as respect to the drug case. Straight away, the 4 appellants are charged for the drug case. The family allegations.
This is true of any case. Whenever we have a case, ultimately somebody may be acquitted. It does not mean that proceeding should not have gone. The proceedings have to go, the process has to be there, and the procedure has to be followed. It does not mean that you will say, no, don't arrest, don't do this thing, don't do that thing. You can't do it. Even if it goes to another agency, the agency will need them. That's basically, you might be that you want to get time, you want to, tamper with the evidence. And as you say, as the other counsel said, that our police action is sometimes doubtful for any reason, for corruption culture or like that. Probably you have the money, you have taken the money, you may be using that tactics also if you are left free for that. So this is a very genuine case. You must allow the proceedings go ahead, in investigation continue. And I think the remand granted is very much genuine.
Your Lordship, if I may please reply.
Yes.
Your Lordship, in this particular case.
1 minute.
Okay. Your Lordship, in this particular case, the counsel would only like to want to conclude that if we are seeing that the case is being initiated for suspicion, if we want the investigation to be correct, to be in a correct manner, and for that matter only we denying the bail to the appellants, that's not the correct grounds, Your Lordship. In this particular case, the straight denial of bail is not correct on the part of the judicial authorities, Your Lordship. As far as the investigation is concerned, we have clearly proved that according to the facts and circumstances of the case and according to the sections drafted, sections of the Drug Act go on to the extent of drafting, to the extent of penalizing the appellants for consumption, procurement, dealing and handling and facilitating with drugs, which is not been mentioned anywhere in the fact sheet, Your Lordship. So how have they penalized or how have they charged the appellants on that particular section? Clearly, the investigation is
even if there is drug in possession, which is more than 5 grams.
Yes, but there is But there's no as such possession, nothing mentioned, no seizure has been currently made. That's why, Your Lordship, the council most humbly submits that the bail should be granted, the investigation should be the court may be pleased to the Central Investigation Agency, as well as the protection from the DCB and FD should be granted, so that a justice can be delivered to both the applicants as well as the deceased in a correct format, Your Lordship. With this, Your Lordship, the counsels for the appellant rest the case.
Moot court चल रहा है. मुल्तानी हो गया.
Okay.
Counsel seeks permission to approach the bench. Counsel seeks permission to address the bench collectively as Your Lordship.
Yes.
Am I audible? Your Lordship, am I audible?
Yeah, please go on.
Much obliged. Lordship, before I begin with my issues, I would like to ask that if you need, I could state the facts of the case in summary format, just for the benefit of the proceedings.
We already heard it. It is better to argue, I think.
Sorry, Your Lord. Your Lordship, before I begin with the issue, I would like to point out that the fact that the appeal was admitted under Article 136 of the Indian Constitution, being an SLP, which was turned into a criminal appeal. Ordinarily, the court does not go into the merits of the case or the facts of the case, but answers questions of law. Specifically, the Supreme Court answers questions of the law, but does not delve into the facts or the circumstances of the case. Your Honor, with this, Your Lordship, I would like to point out to the fact that the evidences at hand and the substance of the evidence and what do they implicate to, or the facts are immaterial for the given proceedings, precisely because the appeal which was admitted was on the issue at hand, which is whether or not is the High Court order passed wrongful in nature, and was it completely ultra vires for them to charge the accused in the said manner. With this, I would ask your permission to present our compendium, Your Lordship.
Please.
Through the screen share option. I would request my researcher to please point out the High Court order, which was, Your Lordship, as you can see, the High Court order is bail cannot be granted under such sections, and send all 4 of them to 6 days judicial custody, altering 14 days sessions court order. The question of transferring the current matter to CIO does not arise. The court ordered DCB and FD to file a charge sheet within 3 days time span. As far as the issue of the media is concerned, we have full faith in them. Your Lordship, the High Court order is this is the entirety of the High Court order. With this clarification, I will begin with my first issue, which is High Court had rightfully denied bail. Your Lordship, in the case of Sanjay Sharma versus Jammu and Kashmir, I would request my researcher to point the compendium to page 17. It was clearly stated that bail can be denied without going into the merits of the case. Your Lordship, the substance of the evidence, or what exactly is the evidence implicating, is the matter of the trial court. At this stage of the trial, we do not delve into the facts or the merits of the case. It is completely, and the onus lies on the trial court to understand what the evidence implicates. Based on the evidence we have collected, there is a prima facie case against the accused, and therefore the High Court had denied bail after understanding the facts and the circumstances of the case.
Mr. Counsel, how is it prima?
Your Lordship, the fact sheet, yes, Your Lordship. Your Lordship, the fact sheet doesn't talk about what the substance is. Right, Your Lordship, I'm coming to that itself. Your Lordship,
tell us how is it prima facie a case?
Right, Your Lordship. To answer that question, I was stating that the Awadh police had collected letters, bank receipts at the place of the crime. Furthermore, Your Lordship, at the crime scene, these evidences were collected. The substance of the evidence is not provided, and that is something the court does not go into. But if the substance was implicative in nature towards the guilt of the accused, that would directly lead to a conviction. Furthermore, Your Lordship, in the fact sheet itself, the accused were recovered from the GCC International Airport entrance gate number 4, clearly pointing out to the fact that they were trying to flee the jurisdiction of this court, Your Lordship. Furthermore, under the section
How do you relate it to the airport? I don't know.
Your Lordship, it is clearly pointed out in the fact sheet that on 5th March, the accused Sohani, Ajay, Atul and Rajiv were arrested by Awadh police from different locations. Sohani, Ajay and Atul were arrested from GCC International Airport, entrance gate number 4.
At what time?
Your Lordship, that is not specified in the fact sheet.
How many hours after the murder, after the suicide?
Your Lordship, on 23rd February, the local newspaper had reported the suicide. The arrest took place on 5th March 2020.
They were found in the airport at 23rd.
No, Your Lordship, they were found on 5th March. Your Lordship, which is exactly
What's the
4 days after.
relationship? Mr. Counsel, where is the relationship?
I'd like to point out to that, Your Lordship. On 28th February.
If you want to take the help of Section 8 and 9 of the Evidence Act, then it should be something which is continuous. That murder has taken place and within half an hour they were found at the airport transacting certain things are going away. 15 days after they were at the airport, what is this?
Your Lordship, let me explain. It is with respect to the fact that on 23rd February 2021, the FIR against all the 4 accused with respect to the IPC charges was filed. Furthermore, Your Lordship, on the 1st of March, DCB had filed charges. Pursuant to this, the arrest occurred under the IPC charges on 5th March, while they were present at the airport entrance gate. Your Lordship, the fact being that at airport, people don't go for leisure walks. Trespassing is something which is not allowed. They were either trying to flee from jurisdiction, which is under the authority, and
There's a presumption.
I understand that. Lordship, that assumption can be.
Seems to be wrong. So anybody can go to airport on particular date and go. Please try to relate it to this crime.
Your Lordship, once the charges
took place on 23rd of February, right? After so many days, certain things have happened in between. Then you are relating it to that. Which part of the law you are applying, sir?
I understand, Your Lordship. I am relating it to the fact that on 28th February and on 1st March, the charges were filed. That is, the FIR was created against the accused. That fourth which, on 5th of March, they were arrested from the international airport, Your Lordship. When the police was aware about...
My goodness. Arrest can happen at the house or can happen at the international airport. How can that be an additional factor that at the airport or the bus stop, they were arrested? I don't think that has much impact on your argument. I can accept it anyway.
I understand, Your Lordship. Just let me clarify to this.
Please produce.
Pursuant to Section 114 of the Indian Evidence Act, this court has the authority to presume certain facts with respect to natural human conduct. A natural human conduct is that a person is present at an international airport's entrance gate only when they are trying to flee from the country, or for that matter, boarding a flight which leaves the country. Yes, Your Lordship. Pursuant to this, I would like to move on to move with my arguments. Your Lordship, if we understand the High Court order, which was that bail in such cases or in such charges is denied and it's not grantable. Your Lordship, I would like to point out the legislative intent here. There is a categorization in CRPC as well as IPC with respect to the bailable and non-bailable offences, clearly pointing out to the fact that in non-bailable offences, bail is a matter of discretion, but not right. The nature of the charges clearly point out to the fact that bail should not have been granted. It was held in the case of Sushila Agarwal versus State of NCT of Delhi that the term in Section 437 may points out to the discretion. Coming to the second fold of the argument, Your Lordship, denial of bail does not infringe the fundamental rights of the accused. The contention of the appellants with respect to the fact that the denial of bail infringes the fundamental rights of the accused is absurd, primarily because Article 21 in its examination itself says that that right, everybody has right to life and freedom with respect to certain reasonable restrictions which are authorized by law. The same was held in the case of Hussain Ara Khatun versus Home Secretary of Bihar. A person is liable to stay in custody and Article 21 shall not be violated as detaining is authorized by law. Coming to the case of Sachendra Priyadarshi versus State of NCT of Delhi, I would like my researcher to point to page number 47 of the compendium. Your Lordship, in this case, it was stated that there is no straitjacket formula for deciding the application, facts, and application of bail. It is primarily done on the facts and circumstances, as was correctly pointed out by the appellant. Your Lordship, we cannot delve into the facts and the facts of the case with respect to the substance of the evidence, because that is not provided in the fact sheet, and that is a matter which the trial court shall handle. The appeal was admitted with respect to the fact whether or not the High Court's order was wrongful. The High Court understood the facts of the case, Your Lordship. The High Court understood that the given accused at this stage are failing the three-prong test, which is given under the P. Chidambaram case, which talks about if the accused is released, he shall be released if this successfully pass the three-prong test, which is that the accused shall not tamper with evidence, the accused shall not try to flee from the jurisdiction, and accused shall not influence the witnesses. Your Lordship, in the given case, the accused tried to flee from the country at one instance. Therefore, failing the three-prong test, the High Court denied bail to the accused. Coming to the third fold of the argument, bail cannot be granted in the interest of investigation and public interest. Your Lordship, in the case of CBI versus Anil Sharma, the Supreme Court had talked about the importance of custodial interrogation. The custodial interrogation is extremely important with respect to the fact that if the authorities are not given a chance of properly interrogating the accused, that could seriously compromise the integrity of the said investigation. The integrity of the investigation.
Counsel, listen.
The accused has not been taken to the magistrate.
In the given situation, bail is to be granted with certain restrictions. They should not leave the country. They should cooperate with the investigation. And then when they are with clean hands, then, you can investigate. You can look to bank accounts. You can look to other things. I think grant of bail will facilitate better investigation.
I completely understand.
And you can see the things, how they will behave, what they will do. That will be a better way, and we can respect our freedom of this liberty also as ensured, guaranteed by our constitution. So why should we take this thing? They were arrested from this place and that place, and might be somebody was knowing the actual culprit is somebody else. So he was knowing that on this date people are going to this place, that place, and they committed the
I completely agree.
offense on the same day, so that the blame will go to them, and so that we can have a better investigation that will be clean and transparent. And we can look to the behavior of other people also, so that many more people will come into there, so we can get
Yes, Your Lord.
better rather than confining these people and not party as they have a right to.
Your Lordship, your voice is breaking.
So bail is a better. Should I repeat?
No, Your Lordship, I got the question.
Okay, then respond to it.
Yes, Your Lordship. With respect to before I begin with the answering the contention, I would like to point out to the fact that, as you had stated, a person, if there was a real culprit, they can clearly talk about the whereabouts of the four accused in this condition and can plot an arrest. Agreed, Your Lordship. But according to the fact sheet, on 28th February and on 1st of March, the charges were already placed. Being suspects in a given case, they should have intimidated either the police authorities or the fact that they, as responsible citizens of the country, they should not have.
Being suspects does not mean that the reality should not be examined beyond that.
I understand. Okay, I understand, Your Lordship, but the issue is not with regard to the fact that we want a further detainment of the accused for the charges under IPC. The prosecution is saying it is trying to validate the order which was passed by the High Court. According to the order which was passed by the High Court, the accused are supposed to be released today itself. We are not requesting a further detainment of the accused. What we are trying to prove is that the High Court's order was not wrongful in nature. Your Lordship, this matter is not with respect.
Where lies the difference between their argument? Your argument is your argument, and their argument is their argument. That's the conflict. You are saying it is correct, therefore he has not been given bail. They are saying it is incorrect, should have been given bail. But what is your argument?
Your Lordship, according to our complete contention,
I agree. Your argument is High Court is correct. But how is it correct?
Your Lordship.
How is it correct?
That's what I'm saying. Your Lordship, for a bail order, the statutory provisions are under section 437. Furthermore, the 437 says that it is a discretionary power. Coming to the High Court's order, Your Lordship, the High Court stated that in such nature of offences, bail shall not be granted. Furthermore, Your Lordship, if you follow the chain of events, it can be clearly pointed out that the High Court had not given bail in the interest of the investigations. Furthermore, to substantiate on this, Lordship, in the grant of bail, there must be a proof of a prima facie case.
As my brethren just said, that the bail could have been granted after imposing certain strict conditions that they will not leave the station, they'll be under the jurisdiction or under the surveillance of police post, or they will have to inform the High Court before they leave. Then the bail could have been granted. Why have they been denied when there is a provision?
I completely agree with your Lordship, but according to the authority of Ram Govind Upadhyay versus Sudarshan Singh, I would request my researcher to point to page number 15. Your Lordship, in that case, it talked about the heinousness of the crime being inversely proportional to the grant of bail. The severity of the sentence also comes in. It is more heinous the crime, the less chances of bail being granted. And the severity of this, after considering the fact that the crime was heinous in nature, the sentence under 306 in itself is for 10 years, Your Lordship, 10 years of imprisonment. This, after considering these factors and the fact that they already tried to flee from jurisdiction once, all of these circumstances and facts were considered by the High Court while denying the bail application. Furthermore, Your Lordship, the High Court had altered the Sessions Court order. They had stated that instead of 14 days of judicial custody, the accused shall be retained only 6 days in the judicial custody. The High Court took in consideration the fundamental rights of the accused and the public interests, Your Lordship. Have I clarified the doubt, Your Lordship?
The High Court could have comprehended that by releasing them and monitoring their behavior, they can better know whether they were guilty or not. Their behavior would indicate. Once they would go for tampering of evidence, they would go for any other kind of activities, they wanted to jump bail, then definitely that could be more helpful for investigation rather than confining them and not allowing any that kind of activities to happen. And they were not ordinary people who could be put in a cage and then you could have the investigation. That could not be possible. The best option was that bail should have been granted and their behavior should have been monitored as can be done.
Your Lordship, the fact being that the accused are supposed to be released today in itself, the High Court has understood this argument that the personal liberty can get hindered, but the issue is that the crime in question was heinous. They need to consider the circumstances as well, considering the fact that
this crime only the heinous crime.
Your Lordship, there are heinous crimes.
Rest of the murders and suicides where bail is being granted, they are not heinous.
Your Lordship, but bail in the first instance is not granted usually. It is not an ordinary course of action that in the very first instance bail is granted. There is custodial interrogation first, and this was held by this very court in itself in the case of CBI versus Anil Sharma. Custodial interrogation in its essence is very important. Otherwise, the integrity of the investigation will be questionable. That is not in public interests. Because a crime is committed in rem, Your Lordship. A crime is committed against the society at large. It is public interests which are getting in question, Your Lordship. With this, I would like to move on to my second issue if there are no questions at this stage of the trial, Your Lordship.
Please carry on.
Your Lordship, the issue number 2 is with respect to the fact that whether or not a media gag should be placed. The appellants are contending that a media gag should be placed. Your Lordship, I would like to point out to the fact sheet again, the only place where media has covered the said matter is on 23rd Feb, where the local newspaper reports the death of the deceased. Apart from this, there are no instances where the media has pointed out or reported the matter in a fashionable manner. For that matter, the Moot proposition does not even talk about any other instances where the media has got involved in the case. The complete contention of the appellants rests on the reasonable apprehension that if that media can influence the judges in the present case. That is the speculation the appellants are having. Furthermore, Your Lordship, I would like to point out, it is the right to know is preferred over the interests of the parties, Your Lordship. This was held in the case of YV Hanumanta Rao versus KR Prathibiram. I would request my researcher to point to page number 67. Your Lordship, the public interests are always held over private interests. As the appellants had rightly pointed out, that if the accused is not granted bail, or if the accused is not released, their income will get affected. Your Lordship, that is a private interest of the parties. That should not win over the public interest of the society at large to see justice get done. This court has the power to reach the truth of the case, Your Lordship. The fact that the accused's income stability, economic stability might get affected, that they are not released in the present matter, is a very absurd argument, Your Lordship. Your Lordship, in the last line, Lordship, it clearly states that there may be cases where the subjected matter is such that the public just a second, Your Lordship. There may be cases where the subject matter is such that the public interest counterbalances the private interest of the parties. In such cases, public interest prevails, Your Lordship. That is what we are contending here, that media should not be stopped from covering the said matter. Furthermore, to substantiate our contention, there are no instances where it has been reported that the media is adjudging on the same issue. They are only reporting with respect to the factual matrix of the case, Your Lordship. If they are gagged from doing that as well, that is stifling voices, stifling democracy, Your Lordship.
But is there any law where the media is permitted to do so? So they will report
under Article 19.
Please. They will report every case, even at the time of investigation, at the time of trial, even before the concluding of the case. Is it permissible somewhere, sir?
Your Lordship, under Article 19, subsection 1, subsection A of the Indian Constitution, right to freedom of expression is given, which is bound by certain restrictions.
But to whom?
Which to each and every citizen, Your Lordship. And journalists are also citizens of the said country, Your Lordship. Sir, these restrictions have been placed on the said right.
One journalist, for the purpose of his commercial activities and other reasons, can do anything which will impact or have influence on judges?
Your Lordship, first of all, if they were doing which was in some manner contempt of court, this argument would not have been brought by the state. It is with respect to the fact that they are reporting and are ensuring the people's right to know. They are ensuring the interest of democracy here, Your Lordship. Transparency is democracy, Your Lordship, and this was stated in the and Your Lordship, that was also that has been held. It was also stated in the case of Manoj Marula versus Union of India, that transparency is an integral part of democracy. Media is the fourth pillar of democracy, Your Lordship. Furthermore, the restrictions which are placed, and the state would.
Counsel, I agree with you. That media is the fourth pillar or 20th pillar of democracy. But what are the limitations on that?
Yes, Your Lordship.
Anything it likes to speak?
Definitely not, Your Lordship. According to Article 9,
what has happened?
There are Your Lordship, I couldn't hear that. Could you please repeat?
आपके केस में फिर क्या हुआ है जिस पर आप आर्ग्यू कर रहे हैं?
Your Lordship, exactly what we are pointing out to the fact is that there is nothing substantial which has taken place. There is no question of media trials being held. They are reasonably apprehending that something of this might happen. And am I audible, Your Lordship? This is the complete argument is with respect to the fact that it is a mere suspicion that media might do something which influences the justice delivery system of the country, Your Lordship. There is nothing substantial. The allegations don't hold no substance, Your Lordship.
No, see, counsel, when you are interested in a very fair investigation, you are
Yes,
confining the people to a cell, and then you allow the you are countering on the point of media also. Then what do you actually want? That should should the media go by the emotional kind of approach and then go for every kind of thing against the people, the social ethos in our country.
Absolutely not.
When you arrest somebody, then stigmatize it, and then fingers start being pointed. So in such a situation, it's better that you must restrict the media in such a situation, so that you get a clear kind of investigation by getting to documents, by getting to facts, by getting to institutions and individuals. Why should you allow, on the one hand, any kind of allegation should come, then emotional kind of that furor is to be created, and at the same time you are confining the people who could also say something about the things. This quite all getting against the basic principles.
Your Lordship, I do agree, but I do agree with the fact that what we are contending here is not with respect to the fact that the accused here should be held more in custody. They are being released today in itself. What we are trying to point out is that there should not be anything done which shall take away the people's right to know and an individual's freedom to express their opinion on the factual matters. If today we restrict the media from covering a case to ensure the private interests of a party, then that will set a precedent that whenever something happens in the country which has a possibility or a pository to
counsel, listening to a rumor today, it's better we know the truth tomorrow. By rumors and by every day without any substantial kind of evidence and only go by assertions. So it's better let's come with the concrete things tomorrow, and society has to get that maturity. And we don't deny the right to know, but it's not the right to know what has been prepared today, cooked today to be put in the media. It's not that. So we have to know it, but we have to know the truth. Society, that's how courts have to behave in such a way that they promote that kind of maturity. It may not be a one-line order. It can be a very speaking order that why media is restricted from certain things, and they may be allowed also. It can't be a blanket kind of restriction. It should be that kind of thing. That okay, we fulfill the right to know. At the same time, it should not be by going by emotions, by going some sentiments, and then creating certain kinds of impressions. We should not go by that.
I agree, Your Lordship. But my contention is with respect to the fact that there are principles which govern this. If anything which media does is in contempt of court, they can be held liable for that. But on a primary apprehension that they might do something which will affect the interest of the private parties is not in essence of the fundamental rights in itself, Your Lordship. Your Lordship, you can. The issue is with regard to the fact that if the media publicates there is a legislation, Contempt of Courts Act, which governs what exactly will be considered as Contempt of Court Act. Article 19, subsection 1, subsection 2 clearly points out to the reasonable restrictions. Therefore, the censorship on an individual's right to expression has already been placed by the legislators. If they do anything in violation of that, they can be held in contempt of the same.
So you want they should first commit it and then you will look to it. You should first commit a wrong and then only you say action can be taken. You should not take precautionary measures.
Your Lordship, why are we presuming that the media will do something wrong? It is with respect to the fact that they are only reporting the factual matrix of the case. It is, we have to look at the rational nexus, Your Lordship. If a person is given priority with respect to the fact that they are innocent until proven guilty, isn't that even applicable in this case? The media is not doing anything wrong at the given stature. But if we stop them from reporting the factual nexus of the case,
will you leave everything to media? Then why are you coming to the court? Should people go to the media then if they are doing everything rightly?
Your Lordship, I don't. I apologize.
Is it that then you will be coming in appeal to the court after the media decides the matters? Is it like that?
Indeed not, Your Lordship. It is with respect to the fact that media has reasonable restrictions already placed on them. If they do anything in contravention with that, the judiciary, or for that matter, any law-abiding authority has the right to stop them and to check them. There are safeguards already placed. But if we stop them even from doing things which are under the ambit on the freedom of expression.
But we have the experience. We have the experience. Media said something about an honest man and he died by heart attack or he committed a suicide. You know, where will you mark the difference? We do have experiences about it.
Your Lordship, I would seek an extension of 2 minutes to answer this question.
Yeah, okay.
Thank you, Your Lordship. I do agree with the contention that there have been instances where the media has overstepped its bounds. But Your Lordship, they were held up for that. The justice was done in that case. The media was held in contempt for that, and they had gone through the punishment they were liable to do so. But the fact that every citizen has the right to opine upon a particular issue, or for that matter, any legal issue in the country. Am I audible, Your Lordship?
Yes, yes.
Okay. With respect to the fact that if they are not even allowed to opine upon any legal issue of the country, merely on the factual matrix which is being reported by the media, then that is wrong. That is threatening the very freedom of expression, Your Lordship, which every citizen in the country is guaranteed. Your Lordship.
Okay, proceed ahead. Okay. You get to your next argument.
Coming to the very last. Yes, Your Lordship. I'll summarize this issue in just a minute. I would like to point out to the fact that in the Beaufort scandal case, it was held that media acts as a safeguard in the justice delivery system as well. They act as a safeguard against perjury or any such offences which might occur. Your Lordship, media is not always in the wrong. They also assist the investigation. They also assist the judiciary in certain matters. That is what we are trying to point out. With this, I conclude my second issue. I would request my co-counsel to begin with issue number 3 and 4. It was an honor pleading before this court.
Right. Yes, please.
Greetings to the bench. Is the counsel audible to Your Lordships? Is counsel audible to Your Lordships?
Yeah.
Yes, audible, but there is PPT of someone. There are slides.
Yes, Your Lordship, that is our compendium which we'll be sharing so as to cite authorities of the court in the matter.
We don't need it.
We don't need that.
Certainly, Your Lordship.
You give the argument straight.
Certainly. Your Lordship, the counsel shall be dealing with the third and the fourth issue at hand. The third issue being that whether the applicant must be granted, whether the appellants in the present matter must be granted from any kind of arrest from the two authorities, firstly the DCB and secondly the Financial Directorate, Your Lordship. Your Lordship, before I begin my oral submissions with respect to this issue, I'd like to point out the issue itself. Your Lordship, the request which has been made by the appellants in the matter is that the court should grant protection from any kind of arrest, Your Lordship. Lordship, this very request goes against the judgments and the guidelines which were laid in the landmark judgment of Gurbaksh Singh Sibia. Your Lordship, the landmark judgment of Gurbaksh Singh Sibia versus State of Punjab considered the 8 guidelines which were pronounced by the Punjab and Haryana High Court. Your Lordship, the Supreme Court in that matter overruled 7 of them and upheld 1 of the guidelines. The one being that no blanket order of anticipatory bail must be granted in any particular circumstances. Your Lordship, if in the present matter, the 2 accused are granted a blanket order of anticipatory bail, that would go against the Supreme Court's precedents and the sections of 438 CRPC, Your Lordship. Before I proceed, there is also a clarification with respect to under what offences the arrest was made, Your Lordship. Your Lordship,
does the fact sheet speaks about anticipatory bail or bail?
apologies, Your Lordship, the council couldn't give.
Fact sheet speaks about bail or anticipatory bail.
Certainly. Your Lordship, the request has been made with respect to granting protection from arrest. Your Lordship, the nature of the request is that the appellants are contending that they are apprehending an arrest and therefore they need protection.
Right. Please carry on.
Should I proceed, Your Lordship?
Yes.
Lordship, I shall be contending this using a 4-fold argument. Firstly, we shall be addressing the relation between Article 21, that is the fundamental right of freedom to live and liberty. Your Lordship, I would like to point out the case of Ramakrishna Balatia, wherein the court clearly noted that grant of anticipatory bail is not an essential ingredient of Article 21, Your Lordship. Your Lordship, this means that the liberty of the citizens in any particular manner, apologies, Your Lordship, must be balanced with the interest of the society. Now, considering the nature of the offences, in the present matter, anticipatory bail should not be granted to the 4 accused, Your Lordship. Now, with respect to the nature of the offences, Your Lordship, the accused are charged under the grave offences of NDPS Act and PMLA Act, Your Lordship. These are the special legislations which were created by our legislatures, keeping in mind the gravity of these offences, Your Lordship. Now, this is this reason why there is a reverse burden of proof in such offences, Your Lordship. Lordship, I would like to point out that Section 35 of the NDPS Act imposes a reverse burden of proof. What this means is that in normal circumstances wherein the accused is presumed to be innocent at the stage of trial and at the stage of bail also, is upon the prosecution to prove that they have a prima facie case, Your Lordship. However, when it comes to NDPS Act, the same proof is reversed and therefore the burden to prove innocence is upon the accused, Your Lordship. Your Lordship, the same reverse onus clause are constitutional, even though they impose a legal burden on the accused to show innocence, Your Lordship. However, Your Lordship, the appellants in the present matter have led their contentions on the basis of the authority of Mohan Lal versus State of Punjab, Your Lordship. Lordship, this was a judgment which in the year of 2018, Your Lordship. And last year only, on 31st August 2020, a 5-judge constitutional bench overruled the said judgment. Therefore, Your Lordship, since the authorities which were cited by the appellants in the present matter, namely Mohan Lal versus State of Punjab, is an overruled judgment, Your Lordship. Therefore, when the court is considering the matter of anticipatory bail, it must be noted that the reverse burden of proof still applies, Your Lordship. Now, expanding upon as to why reverse burden of proof still applies, I'd like to point out to the case of Union India versus Ram Samaj. Your Lordship, with this and another case of Ram Narayan Popli versus CBI, these were the 2 cases wherein the Supreme Court rightfully drew an analogy between a murder case and offences of NDPS Act and PMLA Act. Your Lordship, the Supreme Court said that in a murder case, the accused are committing offences against 2 or 3 people. However, Your Lordship, when it comes to the matters of NDPS Act, the offence are committed against the larger society. The health of the society is impacted. This points out to the gravity of the offences, Your Lordship. Furthermore, when it comes to offences of PMLA Act, it must be the same analogy was drawn by the Supreme Court, wherein it said that a murder is committed against two or more accused, Your Lordship. However, an economic offense is committed with cool calculations and deliberate design. There's an eye on personal profit, regardless of the consequences of the community, Lordship. Now, keeping in mind the gravity of the offenses, while the matter is being decided with respect to the anticipatory bail, the court should not grant any such protection to the 4 accused. Your Lordship, in the present matter, the 4 accused are to be released today from the JC. Now, as of now, the DCB and the Financial Directorate have completed their investigation, Your Lordship, and they would be filing their charge sheet today. Furthermore, if the court grants a blanket order of anticipatory bail, the investigation of these 2 authorities would be affected, Your Lordship. And it is a rule.
Counsel, you can't make it a law that arrests be made and then you go for reverse burden of proof, and what will be the position of the society then? So you have to come with, as the word has been used, contrite evidence. Where is that? You come with that. Where is the contrite evidence with you?
Certainly. Your Lordship, with respect to the matters of NDPS Act and PMLA Act, the law is very clear. The prosecutors don't need to concrete evidence. The only thing that the prosecutor is required to do is make a prima facie case as to show the court that the 4 accused, and there is an apprehension that the 4 accused are guilty of the offense, Your Lordship. Unlike what the appellants are contesting here, that there is no concrete evidence, the respondents and the prosecutors would like to point out that the same is not required, Your Lordship. To further substantiate this, I'd like to point out to the facts of the case, Your Lordship. Your Lordship,
okay, do you agree with it that you don't have any contrite evidence, and you take the help of some technicality that the proof is not required? Is it? Do you agree to that? You don't have any contrite evidence, and you are taking the support of some technicality which has a different context. The context may be different for that.
Indeed not, Your Lordship.
So in any case, how can anybody say, I don't have the evidence and the burden of proof lies on another person? How can one say it? You have to come with some evidence, then only, and that also, as the word used, is contrite evidence. And then you may say ultimately the burden of proof may lie some other person.
Indeed not, Your Lordship. 2 reasons. Firstly, when it comes to the matters of anticipatory bail, the court is not required and should not go into the merits of the case, Your Lordship. The court should not consider the substantiveness of any evidence, Your Lordship. The court needs to merely look upon the factors so as to whether the appellants have this propensity to...
The argument seems to be very funny. The court should not base its judgment on substantive evidence. Then on how will they do it?
Certainly, Your Lordship, when it comes to the matters of anticipatory bail, the court needs to look at the prima facie evidence, Your Lordship, or the prima facie case, Your Lordship. There is a difference between prima facie evidence and concrete evidence, Your Lordship. Now, when it comes to NDPS matter and PMLA matters, we have prima facie case. Now, I'll be contesting the prima facie argument by showing that if we look at the chronology of the case of the matter, Your Lordship, firstly, the case was registered by the Awadh Police, Your Lordship. Now, while the case was registered, there were different evidences which were collected, namely the messages, letters, bank transfers, and bank receipts, Your Lordship. Now, when these bank receipts were collected and when these bank receipts would have been analyzed, the state police authorities would have come to a conclusion that there is a possibility that money laundering and the offenses of money laundering are involved, Your Lordship. Thereafter, a request was made from the Awadh Police to the Financial Directorate, Your Lordship. Furthermore, now, Your Lordship, when it comes to the Offences of Money Laundering Act, Section 3 of the PMLA Act requires 2 things. Firstly, proceeds of the crime. Secondly, illicit transfers, Your Lordship. Your Lordship, the proceeds of the crime in the present matter includes the offences of NDPS Act, Your Lordship. And with respect to the illicit transfers, it is clear that there have been bank transfers made, Your Lordship. Therefore, it has been clarified, and it could be reasonably presumed that a prima facie case has been made, Your Lordship. Because this is precisely the reason why the Financial Directorate, after it, requested the DCB also to get involved. Your Lordship, the progress of investigation has been made very clear from the fact sheet. Firstly, the FIR was registered, the evidences were collected, and after that, the progress was made by the DCB when they arrested a local drug dealer named Smith. These facts, when looked in a chronological manner, Your Lordship, point out that the prosecution has satisfied prima facie that the accused are guilty of the offense, Your Lordship. Now, with respect to concrete evidence, that is a matter of trial, Your Lordship. When the matter goes to the trial court, the appellants and the prosecution would contend the substantiveness of the evidence, Your Lordship. Therefore, keeping in mind the paper trail, the evidences, the chronology of the facts, the prima facie case has been established. Now, with respect to the clarification of reverse burden of proof, Your Lordship, 35 is clear with respect to reverse burden of proof. Now, it is justified when the offense possesses a threat to the society. And here, the primary duty of the state is to protect the society, Your Lordship. Therefore, the reverse burden of proof still applies, Your Lordship, since the prosecutors in the present case have established a prima facie case. Now, Your Lordship, pointing out to the provision of Section 37 of the NDPS Act. Your Lordship, Section 37 of the NDPS Act imposes twin conditions. The first condition is, while granting bail, that the Supreme Court, that the court must be satisfied that the appellants are not guilty of the offense, Your Lordship. Secondly, the court should also be satisfied that the appellants in the present matter won't be committing any offense, Your Lordship. However, the appellants in the present matter have failed to satisfy these two conditions, and therefore, the anticipatory bail must not be granted to the four accused, Your Lordship. Furthermore, moving on to the third fold of the argument, Your Lordship, if Your Lordships are with me and if they have any queries. Your Lordships, are you with me?
Yes.
Certainly. Your Lordship,
we are not with you, we are with the court.
Indeed, Your Lordship. Your Lordship, with respect to the third fold of the argument, we are contending here that anticipatory bail should not be invoked so as to thwart investigation in a matter. Lordship, I'm relying on the judgment of Pokaram versus State of Rajasthan.
Where are you talking of anticipatory bail in this? Who seeks anticipatory bail?
Your Lordship, it has been, the appellants are requesting.
But who is seeking here, no, anticipatory bail? Tell us.
Your Lordship, the appellants have prayed that protection from any kind of arrest from the DCB and the financial.
No, but where is the question of anticipatory bail in this case when arrests have already taken place?
Indeed not, Your Lordship. Your Lordship,
the question of bail or anticipatory bail?
Indeed, Your Lordship, I would like to clarify on the facts of the case.
Because you are taking too much time on this anticipatory. So,
quickly summarizing this,
who is apprehending arrest and then he is seeking anticipatory? No, that's how you are presenting the case with some kind of inaneness, because the people have been arrested and they are not, their right is not respected. So that they can.
Yeah. Your Lordship, the facts need a clarification with respect.
And that's how you are talking of anticipation and anticipation. No?
Indeed. Your Lordship, the council understands.
Are they hiding anywhere? They have not been arrested. What is there?
Indeed. Your Lordship, the council understands the difference between bail and anticipatory bail. Now, in the present matter, the arrest has not been made by the DCB and the Financial Directorate, Your Lordship. The arrest has been made by the state police authorities with respect to
that has already been done. No, that has already been. They are already in the state custody. No, whatever the agency, they are in the custody of the state.
Precisely, this is our argument, Your Lordship, that the JC would be ending today. Now the appellants want that there should be a blanket order of anticipatory bail so that the police authorities, that the two investigative authorities cannot arrest them.
Not anticipatory. Bail should be there. No, bail. They want bail.
Your Lordship, I would like to clarify with respect to the facts of the case. In the third issue at hand, the appellants are requesting for anticipatory bail. Your Lordship, the High Court order was with respect to the bail of offences of IPC. The anticipatory bail is with respect to the offences of NDPS Act and PMLA Act. The request of the appellants is precise.
Proceed ahead. Mhm.
Indeed, Your Lordship. Your Lordship, with respect to the poker state of Rajasthan, the grant of anticipatory bail should not be allowed if it would defeat, thwart, or stall or render the investigation, Your Lordship. In the present matter, the accused have been in the judicial custody and now today they would be released. Your Lordship, we are merely contending that no blanket order of anticipatory bail should be given. With this, the council would like to move on to the fourth issue at hand, Your Lordship. Are Your Lordships with me?
Yeah.
Your Lordships, I shall be dealing with the fourth issue wherein the appellants requested for a transfer of investigation to CIO merely on a speculation that the investigation is biased and tainted, Your Lordship. Your Lordship, in the fact sheet, there is not a single piece of evidence which could point out that the investigation is biased and tainted, Your Lordship. The state police authorities, the DCB, and the financial directorate have making progress with respect to their investigation, Your Lordship. And we shall be arguing this issue using a threefold argument. Firstly, Your Lordship, in the present matter, Section 6 of the DSPE Act must be given consideration. Your Lordship, Section 6 of the DSP Act is the section which governs transfer of investigation to CBI. It requires that state consent must be there when an investigation is being transferred. Your Lordship, in the present matter, the state is not consenting to any such investigation, Your Lordship. Therefore, if the investigation is transferred to CBI without state consent and without imposing the confidence on the three investigative agencies, that would be violative of the principles of separation of power, Your Lordship. Now, Your Lordship, with respect to this, the accused in the present matter do not have the right to choose the investigative agency, Your Lordship. Your Lordship, in the recent matter of Arnab Swamy versus Union of India, wherein the appellant had requested for a transfer of investigation merely on a speculation, the court clearly stated that when it comes to investigation and transfer of investigation, the accused do not have the right to choose the investigative agency. Your Lordship, in the present matter, the appellants are coming to the court on a mere speculation and they want the investigation to be done by one particular authority. Your Lordship, no one can insist that an investigation that an offense be investigated by a particular agency, Your Lordship. An aggrieved party can only claim that once an offense is alleged against them, the investigation is conducted properly, Your Lordship. Your Lordship, there is already an alternative remedy under the CRPC with respect to making sure that the investigation is unbiased, Your Lordship. Your Lordship, the magistrate has the power to direct further investigation, Your Lordship. Now, if the appellants have or get any concrete evidence as to showing that the investigation is biased or tainted, it can very well argued at the stage before the magistrate that the investigation should be directed the case should be directed for further investigation, Your Lordship. Therefore, the investigation should not, and the investigative agency should not be chosen by the four accused, Your Lordship. Now, moving on to the third fold of the argument, Your Lordship, with respect to the facts and circumstances of the case, it doesn't call for a transfer of investigation to an independent authority, Your Lordship. Lordship, the court has time and again dealt with this matter, wherein it said that under what circumstances an investigation should be transferred to an independent authority, Your Lordship. It is a well-settled principle that the same should be done exceptionally and rare circumstances, Your Lordship. The power to transfer investigation must be used sparingly, Your Lordship, and only in exceptional circumstances, Your Lordship, not on basis of a mere speculation that both the agencies are acting on a biased manner, Your Lordship. Again, Your Lordship, in the fact sheet, there is not a single evidence which could point out to the biasness of the investigative agencies, Your Lordship. Therefore, Your Lordship, that if there is an alternative remedy before the court, that must be consumed for accused before coming to the Supreme Court of Saurashtra, Your Lordship. Now, Your Lordship, it is not desirable to deal with the factual merits or the factual disputes, Your Lordship. Therefore, while the court is considering this request, it should keep in mind that such transfers should not be made on a regular basis, Your Lordship. While I'm seeing on the several judgments of Aravali Golf Club versus Chandler Haas and several other authorities, wherein it was made clear that the legislative intent behind making an independent authority was that so that it could investigate into the matters with international ramifications, Your Lordship. Now, the present matter is being investigated by 3 different agencies. Your Lordship, there is a reason as to why these 3 different agencies are being created. Firstly, with respect to the IPC offences, the charges are of abetment to suicide, wrongful confinement, and other such charges. With respect to the NDPS, Your Lordship, the appellants are charged under section 20, 22, 27, and 29, Your Lordship. And the last is the PMLA offence, Your Lordship. The nature of these offences are different, Your Lordship. It is more reasonable for each offences to be investigated by different agencies, Your Lordship, so that investigation is done in a free and fair manner, Your Lordship. Your Lordship, we understand and we accept the fact that appellants and any person has a right to free and fair trial, which also includes the right to free and fair investigation, Your Lordship.
Counsel, which is the most serious offense, which is, under this scan in this matter, which is the most serious one?
Certainly. Your Lordship, with respect to the IPC offences, the appellants in the present matter are charged with the offence of abetment to suicide, which carries a maximum sentence of 10 years.
So when it is so, then all other things are collateral to it. And the more emphasis has to be given on that aspect and which is the correct agency to investigate that. That has to be very important. It's not by bringing the collateral agencies and then diluting the main aspect of it. It should not be there. So that's how we must allow the investigation into the main allegation and main offense. That's what has to be seen.
Indeed, Your Lordship. Your Lordship, the court here needs to consider that,
and that can be done by the ordinary police, and that can be done in the locality itself, and that can be done by releasing the people and then monitoring their behavior, as I said earlier, and looking to the things what they will do, how they will respond to it.
Your Lordship, we agree that has the power to,
rather than creating so many other kinds of, yes.
Your Lordship, the council understands that the court has power to impose reasonable restrictions while granting bail, Your Lordship. In the present matter, Your Lordship, we are not requesting for a bail. We are not requesting for requesting for a bail to be.
No, see what seems by your arguments is that you don't want the main offense to be focused, and you don't want the investigations related to that. You are more about the collateral issues, and that's how, by creating some justification for arresting them, that looks at the face of the argument. You are more interested in keeping them somehow in jail, rather than going to the investigation part of it. So you can bring another act and then talk of that, okay, technically it does not need any kind of thing, one can be arrested again, and then another act you can get, and that's not the main thing. Is the abetment of suicide or murder it can be proved, and there you have to focus on it, and on that you are not having, as they say, contrite evidence. You don't have that to keep them under arrest for a long time. And when there is a very good logical support in this favor that they should be let free so that we can monitor their behavior, technology is very much advanced, and that can be more supportive in reaching to the truth, rather than keeping them confined and things will remain under haze. That's the point. To that you have to respond.
Indeed, Your Lordship. Your Lordship, the council understands that the court has the power to impose reasonable restrictions while granting bail. Your Lordship, I would like to reiterate that
I don't say reasonable restrictions only. I want that they should be allowed
Certainly, Your
to
Lordship.
go
Certainly.
home. Let them see that whatever are the things the normal life they must have, and at the same time monitoring is to be there. That's
Certainly, Your
it's not
Lordship.
yes.
Your Lordship, the court has already allowed bail.
And then also I am concerned about it by having further charges and getting another agency, another charges, another agency, another charge, another agency. That dilutes the main issue, and the purpose may be somebody wants them to keep them confined. Somebody wants that they should not work. They should they must not be able to carry on their normal activities, and if they will remain so away from their job for 2 months, 3 months together by bringing different acts, so their whole business will go, their reputation will go, everything will go. That's ultimately they will be proved they were not guilty, but that's to no help. And how much torture they will suffer. This is you have to see by bringing collateral such enactments where you can keep anybody confined for a long time. That cannot be. That's how the High Court has not looked into that aspect of.
Indeed, Your Lordship. Your Lordship, I'd like to clarify with respect to what we want here first. Your Lordship, we are not seeking a denial of bail or that the investigative agency want further custody of the 4 accused, Your Lordship. The High Court has stated that the 4 of them would be released today, Your Lordship. It is the appellants who want a blanket order of anticipatory bail so that they would not be arrested even if further offences are being discovered, Your Lordship. This would...
But anticipatory bail does not mean that they will not be arrested again.
Your Lordship, an anticipatory bail kicks in.
That's not a permanent kind of bail that one cannot be arrested. If there is a need, they can be arrested even after granting that.
Your Lordship, we understand that the anticipatory bail is not restricting the investigative agency with respect to their investigation, Your Lordship. However, what the appellants are seeking here is a blanket order of anticipatory bail, which means that whatever offences they commit after these proceedings are over, they should be granted bail, Your Lordship. With respect to the CBI investigation, Your Lordship, as Your Lordships have rightly pointed out, that there are 3 different offences. This is precisely the reason why we want that even the accused should be given a free and fair opportunity of the investigation. The moment 3 different agencies investigate into the 3 different matters, the proper investigation should be done and can be done, Your Lordship. If the investigation is transferred to the CIO, that one agency would have to investigate in all 3 matters, Your Lordship. This would in turn would affect the investigation procedure, Your Lordship. Therefore, we request the court to let investigation be done by the state police authorities with respect to the IPC offences. With respect to the NDPS offences, the NCB should investigate. With respect to the PMLA, the Financial Directorate should investigate. Therefore, this is precisely how the court can ensure that no offence is being given priority over the other, Your Lordship. And the offence of abetting to suicide, which is of grave nature in the present matter, Your Lordship, is being investigated in a free and fair manner, Your Lordship. With that answers Your Lordship's query, I would like to proceed on.
Okay, get to another issue.
Certainly, Your Lordship. Your Lordship, this being the 4th issue at hand, we would request in the end that the appellants have moved this court on a mere speculation wherein they have been forming a theory, a conjecture, without firm evidence, Your Lordship. When it comes to the matters of bail, concrete evidence is not required, Your Lordship. Your Lordship, only prima facie case has to be satisfied by the prosecutors to the court, Your Lordship. And the respondents in the present matter have clearly satisfied that there is a possibility of the 4 accused to be guilty, Your Lordship. Your Lordship, denial of bail or denial of anticipatory bail does not mean that the accused are guilty of the offence. We acknowledge the same fact, Your Lordship. This is merely so as to facilitate the investigation, Your Lordship. We would contend before the Honorable Supreme Court that if the transfer of investigation, on a regular basis, this would in turn violate the separation of power and the concept and would impact the credibility of the three authorities, Your Lordship. Because, Your Lordship, the moment an investigation is transferred to one agency rather than these three agencies, it would be coming to question that are the would come to question, Your Lordship. Your Lordship, I'd like to
you give him another 100 seconds. Okay? Give him another 100 seconds to clarify and conclude.
Your Lordship, I shall be addressing the prayer now, since the council has addressed the third and the fourth issue at hand. Lordship, in the light of the present case, the issues raised and the arguments advanced in the authorities cited, we pray before the Honorable Supreme Court of Saurashtra that it may be pleased to uphold the judgment of High Court, which was a reasoned order, which provided with the reasons of the order and kept a balance of the fundamental rights of the appellants and the public interest, Your Lordship. Furthermore, we request the court that the media coverage with respect to the facts and what is going around with respect to the case should be allowed, and a gag order and in the nature of a pre-censorship would violate the fundamental rights of the freedom of speech and expression, Your Lordship, and the same would not be coming under the reasonable restrictions, Your Lordship. Thirdly, we request the court to deny a blanket order of anticipatory bail, as it would go against the general guidelines of the Gurbaksh Singh Sibia judgment also and the general provisions of anticipatory bail, Your Lordship. At the end, Your Lordships, the council requests the court to deny the request of transfer of investigation, since the appellants in the present matter firstly do not have the right to choose the investigative agency, and secondly, should not be making a request of transfer of investigation on mere speculation, Your Lordship. With this, the council ends its oral submissions. If Your Lordships have any queries, the council would be highly obliged to address them.
Okay, the time is over.
It was honored to plead before this Supreme Court.
Thank you, participants.
Yeah.
Thank you, judges. It was indeed a great honor to have you with us for the proceedings of this round.
Okay.
I would like to extend my deep sense of appreciation towards our guest, who, despite of their busy schedule, has spared some time to grace us with their presence and be a part of this event. Our first judge, Professor M. Afzal Wani, Sir is presently Professor of Law and Director, Coordination, GGS, Indraprastha University, Dwarka, New Delhi, with more than 35 years of teaching and research experience. Earlier, he served as member of the Law Commission of India from 2009 to 2012, and as an elected member of the Governing Council of Indian Law Institute, New Delhi. Notably, he coordinated the Rule of Law project of United States Agency for International Development, with due success to build the capacity of legal and juristic departments of Afghanistan, including training of law ministry officials, judicial officers, and law professors of Afghanistan universities as a process of reconstruction of Afghanistan, exhibiting his best capacity of introducing peace perspectives to intellectuals of otherwise disturbed areas. He, with due appreciation, completed an assignment of ILO in preparing a document on introducing modern labor law standards to traditionally oriented societies. His area of interest are jurisprudence law and development, focusing on comparative jurisprudence and human rights in peace. He has authored more than 10 books. He has also produced 10 PhD scholars so far. He has presented papers in various conferences at home and abroad at Oxford, Stanford, and many prestigious universities. A second judge, Professor S.C. Raina, Sir has been appointed as the first Vice Chancellor of Himachal Pradesh National Law University. He started his teaching career as a lecturer in Law Department of Aligarh Muslim University in September 1979. He is also former Dean of Faculty of Law, Delhi University. Also, he has a vast teaching experience of 35 years. A big thank you to both the judges for their encouragement, support, and cooperation. I would now request our faculty in charge to please deliver a vote of thanks to our esteemed guests.
Putting charges, before that we have certain queries from our teams here, and I would like court master and court in charges to look into that first.
Sorry to interrupt, Court Master, but
The teams want to proceed with the rebuttals and sir rebuttals.
Okay, I think we can go with that. If you want, we can go with it. You can give an opportunity. Yeah.
Can we proceed, sir? Your Lordship, the counsel for the appellants have to point out a few areas in the argument.
Okay, they are allowed. Okay. You give them limited time. Okay. 5 minutes.
Your Lordship, in this particular case, the counsel for the appellants want to place a few reliance on few cases and end the argument. Firstly, with respect to the maintainability of the petition, the counsel for the appellant states that in the cases of grave and substantial injustice, the Supreme Court can entertain petitions under Article 136. Secondly, on the aspect of bail, Your Lordship, there are two areas. First is bailable offences, second is non-bailable offences. And in this particular case, we have charges of both the bailable and non-bailable offences being filed against the appellants. However, Your Lordship, unless there are some cogent reasons for the custodial interrogation and sustained detention at a pre-trial stage, detaining an individual and encroaching his right to liberty is considered to be punitive and against the principles of natural justice. For this, Your Lordship, the counsel seeks to quickly place reliance on two cases of Supreme Court. First is Rasiklal versus Kishore Khanchand. It's a 2009 judgment in which the Supreme Court has stated that the right to claim bail granted by the Section 436 in bailable offences is an absolute right and an indefeasible right. In a bailable offence, there is no question of discretion in granting bail, as the words of Section 436 are imperative. And even in cases of non-bailable offences, the Supreme Court in Seema Singh versus Central Bureau of Investigation 2018 judgment has again reiterated that the accused charged with serious offences by itself is not a ground to deny them a bail if there are other circumstances justifying the grant of bail. Your Lordship, this particular case is on a pre-trial stage, and denying the bail to the appellants in this particular scenario would be grave injustice. Your Lordship, further, the respondents have went on to point out that our 2018 Mohanlal versus State of Punjab judgment in case of reverse burden of proof was reversed. However, Your Lordship, the counsel for the appellants would like to state over here that the judgment was reversed only on the other aspects relating to whether an investigation conducted by the police official who himself is the complainant would vitiate the whole trial and acquit the accused. This particular factor of overruling the judgment in no way affects our case. Further, Your Lordship, the counsel would seek to place reliance on a very recent judgment of Arnab Goswami versus Union of India, in which this Honorable Supreme Court has held that and intervened to protect the rule of law and also protect the rights of an individual, and held that detention of a person infringes the right to life and liberty guaranteed by Article 21 of the Constitution, Your Lordship. And same is happening in this particular case as well. There are no evidences put forward. There are no arguments by the respondent's side to prove that the continued detention should be there and the cases of NDPS or PMLA should be initiated. That's it for the rebuttals from the side of appellants, Your Lordship.
Okay.
Counsel seeks permission to address for sir rebuttals.
Please.
Thank you, Your Lordship. Firstly, the counsel would be answering the question pertaining to the fact that why there are no arguments with respect to what the evidence entails, what the substance of the evidence entails, and why there are no arguments with respect to the validity of the charges placed. primarily because this petition has been entered under Article 136 of the Indian Constitution, Your Lordship. It is a criminal appeal dealing with the matter of whether or not the High Court's bail order was valid or not. The bail was not admitted with respect to the trial of the offences. Second, Your Lordship, coming to the contention that these are not grave and that these are grave and exceptional circumstances, Your Lordship, detaining a person for non-bailable offences is something which is a routine task. As pointed out by the bench in itself, that it is a discretionary power of the court to grant bail in non-bailable offences. It is routine and it is in ordinary course of action. People are detained under bail pursuant to Section 437. Therefore, does not invoke grave and exceptional circumstances, which is an important factor for invoking the jurisdiction of the Supreme Court under Article 136 of the Indian Constitution. Pointing out to the fact that there are bailable and non-bailable offences within the charges which are placed on the accused. Completely agreed. But Your Lordship, the primary charge which has been placed on the accused is abetment to suicide. There are evidences on that as well. The evidences which will be scrutinized at trial, but the evidences do exist. The substance of the evidences has not been provided in the fact sheet, and assuming that they implicate the innocence of the accused is misleading the court, Your Lordship. Therefore, High Court, after understanding the circumstances and the factors of the case, denied bail to the accused, acting under their discretion, passing a reasoned order using application of mind and the concepts of natural justice. Lastly, Your Lordship, the appellants mentioned the Arnab Goswami case. They do hold, it was stated that the principles of natural justice should be held, but it was also stated that the petitioner cannot choose their investigative agency, Your Lordship. It was immature on the part of the petitioners to point out to the fact that the Awadh police are incompetent to conduct the said investigations. Thank you, Your Lordship. It was a pleasure pleading before this court.
Okay, thank you.
I would like to invite the faculty in charge to present a vote of thanks to the judges.
I would like you to take over the.
Thank you, ma'am. I request all the participants to please leave the meeting and join after some time for the valedictory ceremony. And I request the judges to please fill the score sheets.
Do we join through the same link?
Yes, you have to join to the same link.
Okay, thank you.
You're welcome.